question of jurisdiction and determination of constitutionality of sections. Council is dealing on an abstract matter. My two councils said here they shall follow that elsewhere. So we have not said this court has no jurisdiction. And we have not said that this court should declare the judgment effective or unconstitutional. That is the whole issue we are raising. So my good friend JV is delving into matters that were not raised by any of the defense counsels.
Yeah, just to help the court contextualize, when my learned senior Mr. Omari rose, the first thing he told you is that he was going to give you a context and not the law. However, as he started, the first thing he told you is there is a fundamental issue of Article 27. That could have been in record. So what I'm basically saying
if
is...
I bring in clear, Article 49 that defines provisions for compelling reasons is a constitutional...
Let me deal with the question.
No, I was only finishing that to bring to perspective that the courts here, magistrates, look at Article 49.
Yes.
They apply it,
yes,
but they cannot interpret it. So what we are trying to say is that, Your Honor, we are not asking for constitutional interpretations from you, or a finding that is based, or a constitutional finding. All we are saying, apply those ones as the law allows.
Thank you, Jan. That admission works for me. I have actually finished my submissions on that. I remind this court, it did not have to come from the defense for me to raise a question of jurisdiction. We are just reminding you that all the articles of the Constitution that were raised cannot be heard or determined by this court, and we will wait to address them before the High Court. I am done with that question. And, Your Honor, we plead with the court to take down that admission by counsel, that they admit you are not the right forum to handle issues of constitutional violation. Secondly, I'll now come to the question of the role of the Office of the Director of Public Prosecutions. We have been accused of coming with unclean hands before you. Learned Counsel Ms. Bashir raises a contractual maxim not applicable to criminal law, that anybody who comes to equity must come with clean hands. Anyone who comes to equity must come with clean hands. Even if the maxim were applicable, the obligation to prove that our hands are dirty was on Ms. Bashir. She has failed to prove that our hands are dirty. In fact, according to her, we should have been the one to prove that we have clean hands. That's against the rules of evidence. However, Your Honor, this is very critical considering the context of this case. The Office of the Director of Public Prosecutions, as established under Article 157 of the Constitution, has a role that is circumscribed. That role is clearly delineated. I will tell the court one thing that role does not include. It does not include supervisory powers over investigative agencies. Put differently, the Office of the Director of Public Prosecutions is not an appendage, neither of the National Police Service, nor of any other agency in the Republic of Kenya. Why do we say this? Sorry, Your Honor. Questions have been raised as to the right to liberty, the arrest of the respondents. At what point do you trigger the powers of the Office of the Director of Public Prosecutions? The powers of the DPP in exercising the mandate under Article 157(6) of the Constitution are only triggered when an investigative agency has forwarded an inquiry or investigative file. The investigative file, the subject of this matter, was forwarded to the office today, and in record time, around 4 hours, the decision to charge, which in ordinary cases is made within about 14 days. In 4 hours, we had made the decision to charge, and we are before you.
You're still to help of counsel.
I know the office of the DPP is vacant, and they might be shortlisted to contest for that position.
Let him look at Article 157(4). If he will be confirmed as the next ODPP, he has the powers to direct the police. If he's admitting here that they do not have that power,
Then we have a big problem.
Your counsel is deliberately misquoting me,
unless it's not
I
a
think to his advantage. The powers under Article 157(4) of the Constitution is given, in fact, it's the only power, the rest are mandates. The power of the DPP under Article 157(4) is to direct the Inspector General of Police to carry out investigations into alleged criminal activities. That cannot amount to supervision. In fact, to confirm that, you read Article 245(4) of the Constitution, which, sorry, Your Honor, the law in me is...
Be careful, you might be sitting up there.
So Your Honor, the supervision of the National Police Service is elsewhere, not with the ODPP. And like I've assured, I think this is in an assuring manner. We are not an appendage, and we are not a conveyor belt of charges. For us to come before you today, as already indicated, a decision to charge was made in accordance with the Constitution. The Office of the Director of Public Prosecutions Act number 2 of 2013. The ODPP decision to charge guidelines, on which the only test required of the Director of Public Prosecutions, or those of us exercising delegated authority, is whether or not there is evidence with a realistic prospect of a conviction. We may have been wrong in making our decision all right, but that determination will be made by the trial court. And that's why we have presented charges before you. We shall be expected to bring evidence.
Your Honor, if I may, and we do not want to interject our colleagues. With the kind permission, Your Honor, and just to save the court's time, and my colleague comes from my region, so we want to speak a lot, but there is no question about their power or the decision to charge. We do not challenge that. That is theirs, absolutely theirs. The question that is before you is that affidavit that denies them bond. They've already taken plea. We are okay with that. We'll deal with that. But the issues that we believe the court is interested in is the issue of whether there are compelling reasons. And he's avoiding that because there's no compelling reason.
Your Honor, I have that as my next issue. The court was here when a lot of arguments were made on why the office of the DPP has perpetuated an illegality, has violated the Constitution. We have a right to respond to that. That's actually why we're representing the ODPP here. That accusations were made against us. So just like we were very patient with counsel, let them be very patient with us. It is very important to us, just like it is important to their client's case. So I plead with this court to allow me to respond to all the issues that they raised, and I'm almost done. Our next point is on the question of Article 49, on whether or not there exist compelling reasons. And Your Honor, we started with the question of jurisdiction. To guide this court with humility, that is the only question that arises for your determination. Not the 98% of the submissions from the defense. You know, first of all is the technical question about whether or not the affidavit is dated. It is not. However, a look at page 2 of the application makes reference to the deponent of the affidavit. Page 2 of the application. It identifies the deponent of the affidavit, and the affidavit speaks on the grounds in support of the application on the same page, page 2. Those grounds are 1 to 4 on the face of the second page. And finally, on that page 2, the application is dated. We therefore invite you to invoke Article 159 because the affidavit is stamped duly and it is signed. Invoke Article 159 to and find it proper. For the avoidance of doubt, no application was made to you to strike it out. To the substance, when you retire, Your Honor, you are going to ask just one question. And that's probably what should have come from the defense, and we should have responded to in rejoinder. Whether or not the prosecution has established any compelling reasons to deny any of the respondents' faith. I reiterate the submissions of my learned senior on the contents of the application and the affidavit. Only to further refer this honorable court to clause 4.9 of of the Judiciary Bail and Bond Policy Guidelines, Clause 4.9. And more specifically, 4.9c on character and antecedents, 4.9e on possible interference with investigations, and 4.9g on possible interference with witnesses. Those grounds are again on the face of page 2. Just before you go to page 2, the prayers on the application, and then on page 2 we say the grounds number 2, number 3, and number 4. Likelihood of interference with witnesses at ground number 3. Likelihood of interference with ongoing investigations, and finally the possibility of committing similar offenses, which goes to antecedents. Where do we get the facts? My learned senior Mr. Owino asks the question, whose reasonable belief? The belief is of one Corporal Geoffrey Mwangi. He identifies that belief in the affidavit, as should be done. What is the source of the belief? He identifies.
With your kind permission. Your Honor, this is usually not my ordinary playground, and Mr. Whitty knows it. But I believe the rules still apply. He is supposed to be limited to questions of law in his regime.
Yes.
And I think it is unfair for the accused people for him to start raising or making allusions, factual allusions that we will not have an opportunity to respond.
On that basis, because I was silent, awaiting for the opportunity to raise that issue. And Mr. J.V. Learned Hansel for the DPP, when addressing the question of the pre-arraignment detention, he did not direct you to look at the charge sheet on the date of the arrest, which is the 18th, and the date of presentation to court, which is 20th. I thought it was important for me to point out.
You know, maybe
No explanation has been
that last.
And no explanation has been offered. They never disclosed, and this is their charge sheet, unless they are denying it.
That's okay. We'll address that last. I was concluding on the issue of whether or not there's compelling reasons. We invite you to look at that. Sorry, Your Honor. Sorry.
The issue that Mr.
Owino.
Yes. It is the reason that I have said I'm concluding on that issue, so that I don't go on the issues of facts. I think that was guidance. I am very well guided. And in conclusion, we invite you that when you retire and look at the matters of fact on the affidavit, vis-a-vis the prayers in the application, you find that indeed there has been established compelling reasons to deny. There are two questions of law that are left, which I conclude with. Edwin Shisanya Amboso versus Republic is a decision of the Honorable High Court, Justice Mugambi, that you've been referred to. We have agreed, and it makes sense, that there is a distinction between the orders granted in Edwin Sishanya, which rejected an invitation to declare assemblies unconstitutional or to issue conservatory orders to that effect. The charges before you are in respect of a criminal offense defined under section 77(1) of the Penal Code. We admit and agree with the defense that there exists orders of the High Court upholding the right to assembly.
Thank you.
We, however, are saying that what we have brought before you is charges for alleged criminal offenses which will be determined upon hearing. Finally, the question about the dates on the charge sheet. I would have referred to 3 provisions of the Criminal Procedure Code. One of them, section 89.5. There was no invitation from the defense or any allegation that there was any impropriety on the charge sheet. And there's no order of this court rejecting charges, which would have happened under section 89.5. Number 2, Number 2, section 382 of the Criminal Procedure Code provides for an allowance in error of dates and names, among many other errors. And so that doesn't affect the validity of the charges. Number 3 is that this court has the powers to direct suo motu or upon application by the prosecution to amend charges. That is still available. That power and right exists all the way until before the accused is placed on his defense. In conclusion, Your Honor, you have been invited to send a message. I am only concerned about the message you're sending to the prosecution. We plead with you that we have not shown, or you've not been shown any fault on our part to send any message. But even if you should, your role in this matter is to determine under Article 49(1)(h) whether or not there are compelling reasons or not to release the accused persons on bail. If that is the manner you are going to show or send us a message, we welcome it. No, Your Honor, far from it. I'm neither threatening the court. There's the issue I've been reminded about place of detention. Should this court not be able to make a determination in the next few minutes? And I have been advised by the Deputy Director of Public Prosecutions, who I am pleased to be leading me today, that we are not objecting to the accused persons being held at a police station. However, she has advised me that the police officers will have a discussion with where to place them, which police station to place them.
Off record. The day they'll arrest you, they'll take you to Cancun. That is a honorable member of parliament. Let us treat our leaders with respect, away from the police. When I was dealing with the SSU matter, I'm only talking to him as a friend. This is off record, Your Honor. Off completely record. I'm advising him.
We can talk about this off record outside.
No, I'm only advising state officers.
Your Honor, again off record as he has applied to be my boss. Yes, Your Honor, we are done. I'm just reiterating that we have no objection to the accused persons being taken off. And when you become my boss, we will still do this.
Roman, under me it will be very different.
Thank you, Your Honor, for your time. I was
Your Honor, very. I know it's completely out of order, but I couldn't fail but notice one thing which my learned good friend did mention, that ordinarily the decision to charge takes about 14 days. But they did it within a record 4 hours, which of course we commend, even though we have reason to worry about the speed at which they approved that charge. Secondly, some of the suspects who were in Babu were also driven here at extremely high speeds. So that means I'm just speaking to the urgency in resolving this matter and still renewing the plea that we made before you. Understanding, Your Honor, that really you've had a long day. And if we can get a decision from you before we depart from this court, we will be greatly indebted to the court. But in the event, and then at the earliest, Your Honor, we